13. Note 13 provides for the effect of this clause, and then subclause 2, that's page 145 of the English version. Accordingly, in applying section 85A of Cap 227, subsection 1E of that section must be disregarded. Now, if I may refer members to note 14, it shows the effect of this clause and how this section is modified. And then subsection 3, page 147 of the English version. This section does not limit the application of any other provision of this division to the case to the extent that the other provision of this division is not inconsistent with this section. Ms. Carmen Can. Chairman, I'd like to seek clarification from the Department of Justice. Application for discharge without hearing. As I understand from the administration's explanation, if the evidence is so flimsy that it cannot support the charge itself, it will be a waste of time to proceed with the trial. And that's the purpose of having this stage in the hearing. Now, if a certificate is issued under Article 46 of the HKNSL such that the case can be tried without a jury, and of course, under Article 46 of the Hong Kong NSL, the Secretary for Justice will issue this certificate under certain circumstances. And in this case, a 3-panel judge will be formed in place of a jury. And as such, the requirement of a certificate or Section 16 of the Criminal Procedure Ordinance will have no effect. Can you further explain this point, Mr. Lau? Thank you, Ms. Khan, for your question. For a jury trial of a criminal case vis-a-vis a case tried by a 3-panel judge after a certificate has been issued under Article 46 of the HKNSL, the biggest difference is that the judges will not be required to provide a written justification of their ruling, whereas if this is a jury trial, a written judgment will be necessary, setting out the justifications. Here, if the evidence is flimsy, in the case of a jury trial, in the end, the defendant may still be convicted without any ground being provided. So the purpose of having a committal, having this application for discharge without hearing of a committal, is that the magistrate will be able to hear the evidence and decide whether there is at least some evidence to support the charge before the case is taken to a higher level for a jury trial to be conducted. In the case of a 3-judge panel of an NS case, the judges will, of course, carefully analyze the evidence. They will also be able to apply the relevant laws. In the end of the day, regardless of whether there is a conviction or acquittal, the judges will provide detailed justifications of their ruling. And as such, the defendant will have a very clear idea of why he's been convicted. And if he's aggrieved, he can then appeal against the conviction. Now, if a 3-panel judge hearing is held, Section 16 of the Criminal Procedure Ordinance will have no effect. However, in the normal circumstances, a halfway submission or no case to answer submission can still be made by the defense in a criminal trial after the prosecution has adduced all evidence. And at that stage is for the judge to decide whether the defendant has a case to answer, and only when there is sufficient evidence will the defendant be found to have a case to answer. Now it's clear for the three-panel judge, since the ruling will come with justifications set out, and at this stage, and there is also the stage in which the defense can make a no case to answer submission. And that is why, if a certificate is issued in relation to such a case, Section 16 will have no effect. Dr. Kennedy Wong. I think to a layman, they may not understand what Clause 104 entails. 104 reads, accused not to apply for discharge without hearing after committal. This is, of course, a major principle. To my understanding, you can apply for a stay of proceeding. That means you can apply to the court for a stay of proceeding order for discharge without hearing. That means you don't have to answer the case. That means during the trial, the defendant can make this application to stay the proceeding. Now, for the benefit of the public and this committee, can you tell us what proceedings we are referring to? Mr. Leung. Thank you, Dr. Kennedy Wong, for your question. Clause 104 relates to only one application, and that is the application for discharge without hearing after committal under Section 16 of the Criminal Procedure Ordinance. Dr. Kennedy Wong refers to two applications. One is a no case to answer application. Now, after the trial has begun and after the prosecution has adduced all evidence, the defense can apply for a no case to answer ruling, and this right is preserved. The other application, as Dr. Wong put it, is application for stay of proceedings. Again, this right is preserved. This is part of the defendant's right to a fair trial, and the courts are required to ensure fairness and impartiality. And this is also enshrined in Article 5 of the HKNSL on equal justice and fair trial. If the court is of the view that a fair trial cannot be conducted, then there is inherent jurisdiction for the court to stay the proceeding. In some extreme circumstances, even when the defendant receives a fair trial, if abuse of process or ultra vires is involved by some authorities, then the court has the power to order a stay of proceedings. These hearings or proceedings are not bound by Clause 104. These two kinds of applications remain the gatekeeper to a fair trial. Well, thank you, Mr. Leung. You just made a very important point. I think for the benefit of the public, what this means may not be very clear. So thank you. Mr. Lai Tong Kwok. Well, I'm not very familiar with the Criminal Procedure Ordinance. I just want to confirm if my understanding is correct. Now, under the existing ordinance, before passage of the bill, once the magistrate decides to commit the defendant enjoys the right to apply for discharge without hearing. With passage of this bill, the defendant will no longer be entitled to make this application. Meanwhile, whilst waiting for trial at the district court or at the court of first instance, are you suggesting that the defendant will no longer be able to apply for discharge without hearing, and this mechanism will have been scrapped? Thank you, Chairman, and thank you, Mr. Lai, for your question. For national security cases tried by the Court of First Instance, it is not the case that no case is tried by a jury. It depends on whether a certificate has been issued in relation to the case under Article 46 of the HKNSL. Now, in the absence of a certificate, it means that this will be a jury trial, and in that sense, the defendant can still apply for discharge without hearing under Section 16 of the Criminal Procedure Ordinance. Let me turn to the question on the district court. The case is usually presided by just one judge, and there is no mechanism in relation to application for discharge without hearing. I think Mr. Lai referred to cases awaiting trial at the court of first instance and whether that defendant will be able to apply make this application. Now, as far as the common law is concerned, when there is an amendment to the statute law, once the amendment takes effect, it will apply to all criminal procedures. This is different from the Crimes Ordinance. Any amendment to the Crimes Ordinance does not carry retrospective effect, whereas for criminal procedures, say if the SJ has already issued a certificate under Article 46 of the HKNSL, after passage of the bill, the defendant will not be able to apply for discharge without hearing under Section 16 of this Criminal Procedure Ordinance. But the two other applications still apply, as I explained. Ms. Carmen Khan, so what is the effect of subclause 3? Security Bureau. Who would like to take this question, please? Just a moment. Okay, when you're ready.
Okay. 係多謝主席。我諗呢個條文咧，佢要處理嘅咧就係
Yes, Chairman. This subclause refers to certain circumstances, as we see in clause 104. I'm sorry, it should be 103. During the committal stage, before the SJ issues a certificate, for a magistrate to commit the accused for trial in the court of first instance, the magistrate will need to issue certain warnings, one of which is that the accused may apply for discharge without hearing under Section 16 of Cap 221, and I think this subclause here refers to the applicability of this warning. Well, if we consider Division 3 as a whole, it refers to certain amendments to the criminal procedures, and that certain processes will be streamlined. So without this, I mean, as long as this section is not inconsistent with others, then after the SJ has issued a certificate, as long as there is no inconsistency, the other parts continue to apply. Yes, your understanding is correct. Mr. Holden Chow, second round. Oh, sorry, first round. Chairman. Well, I heard the administration loud and clear, but for the benefit of the public, I just want to say that this is a very important point. Accused not to apply for discharge without hearing after committal. From the perspective of safeguarding the defendant's rights, we need to make it clear that the two other avenues are available. That is application for stay of proceedings as well as application for no case to answer. These two applications may still be allowed after passage of the bill. Only that the accused may not apply for discharge under this mechanism here. So despite taking away the accused right to apply for discharge without hearing in this circumstance, other avenues are still available. That's no case to answer submission as well as an application for a stay of proceedings. We need to explain with the greatest clarity possible to the public that these safeguards remain in place. No further response, right? No. Isn't it simple and easy to understand? Here it refers to application for discharge without hearing after committal. In the whole context, this case is to be committed to the court of first instance for a jury trial. If the evidence is weak, the accused still stands to be convicted. There is a risk, so the accused may apply for discharge without hearing. Now, if a certificate is issued under Article 46 of the HKNSL, it means that this is no longer a jury trial. The case will be tried by 3 judges. And these are professional judges. They will carefully analyze the evidence. So the situation is different from having a jury trial. They're in a better position to gauge the evidence. And as such, the application for discharge without hearing after committal no longer applies because the case will now be tried by 3 judges. As for no case to answer application or application for stay,
Clause 105. Thank you, Chairman. Clause 105 is about lifting of restrictions on reports of committal proceedings. According to existing rules, no one is allowed to report on details of committal proceedings except for the essential details of the proceeding. However, if the defendant applies or make an application, the magistrate will have to lift the restriction. This may cause unfairness to another defendant of the same case, and it may also prejudice the fairness of the case. This may also endanger national security. Therefore, from the perspective of safeguarding national security, if the defendant applies to lift the restriction on reports of committal proceedings, the magistrate would have the power to exercise discretion on whether to lift the restriction. Please look at the marked up copy. Clause 105 states that this section applies in place of section 87A bracket 2 of cap 227. Section 87A concerns restrictions on reports of committal proceedings. If a defendant makes an application in this regard, then this section would apply. Page 117 of the Chinese version of the paper. Even with Section 87A of Cap 227, the magistrate can make an order to not lift the restriction. For subclause 3, however, the magistrate may only make an order under subsection bracket 2 on being satisfied that doing so is necessary in the interest of justice and would not be contrary to the interest of national security. Subclause 4. An order made under subsection bracket 2 must be entered in the magistrate's case register. Subclause 5. If there are more than one accused in the case, the reference to the accused in subsection 2 is a reference to one of the accused. Subclause 6 states that for the purposes of section 86 bracket 1F and 87A bracket 4 and bracket 7 of Cap 227, an order made under subsection 2 is to be regarded as an order made under section 87A bracket 2 of Cap 227. The effect of the relevant provisions are stated in footnote 16. Thank you, Chairman. Questions? Reverend Peter Kuhn. Thank you, Chairman. On the restrictions on reports of committal proceedings, I think in other Bills Committee meetings, we referred to the word to use the other character now because it has to do with how we interpret section 87A of Cap 227 is a rather old ordinance. And we are referring to how Cap 227 is interpreted here. That's why we adopt the old way of writing of this Chinese character in this particular clause. Mr. Holden Chow, I have a question about the drafting of this clause. Cases. The magistrate would have to consider whether the disclosure of relevant information or the making of relevant reports would endanger national security. Under this bill, the magistrate is still given the power to exercise a discretion. That is, if a defendant makes an application, the magistrate could still lift the restriction. My question is this. Clause 105, subclause 2, if you look at the purple box here, the original section 2 is removed or repealed. I want to know the difference between the original drafting and the new drafting. I can't really tell the difference, so I'd like the administration to clarify. The way you draft it now, that is subclause 2, is very clear, but I want to know the meaning of the original subsection 2? Mr. Leung, thank you, Mr. Chow, for the question. In committal proceedings, by default, as stated in Section 87A of Cap 227, apart from the magistrate's name or the defendant's name, nothing can be reported, and this is the restriction on reports of committal proceedings. However, under Cap 227, Section 87A, subsection 2, the original provision is that upon the defendant's application, the magistrate shall not apply, should make an order. That is to lift the restriction. There was a judicial review case that had to do with the interpretation of subsection 2, section 87A. The judge in that case finds that as long as the defendant makes an application, then the magistrate would not have the discretionary power. That is, the magistration must lift the restriction on reports of committal proceedings. Under such arrangement, what kind of circumstances would arise? First, if the case involves more than one defendant, if only one defendant makes the application to lift the restriction, whereas the other defendants object to the application, the magistrate will have to lift the restriction on the report. I mentioned about the ruling of the judicial review case. The judge noted this problem, and according to the judge, it should be up to the judiciary to decide what to do. In the UK many years ago, the relevant legislation had been amended. I mentioned that such rigid approach would cause problem. That is, if before a trial begins in a national security case trial, if there is information or evidence that is disclosed in a stage too early, it may cause national security risks, and it may also be unfavorable to the future ruling of the case. Therefore, we think what is appropriate is that we should first amend the rigid approach, and we should give the discretionary power to the magistrate as long as both the prosecution and the defendant can make applications to lift restriction on the report. Then it would be up to the magistrate to decide whether it is necessary in the interest of justice to make a decision, given that national security would not be endangered. Any follow-up questions? If not, administration, please carry on with clause 106. Chairman, we should go to item 12B on the reference table. It is about amendments to the Criminal Procedure Ordinance, Cap 221. That is page 165 onwards of the Chinese version of the document. Thank you, Chairman. The amendments made in Division 10 concerns the Criminal Procedure Ordinance. There are a few parts to the amendments. I will give a briefing first before I go into the details of the amendments. On treason, or the offense of treason, there would be relevant amendments. This also concerns Section 79I of the Criminal Procedure Ordinance concerning the legal procedure of handling national security case, and also it is in relation to Article 41, Bracket 4 of the NSL. Amendments are made to the Criminal Procedure Ordinance, Section 123. I now go to the provisions. Please turn to page 165 of the document. That is a Chinese version. We are amending Section 9 about rules and orders as to practice and procedure. Please refer to 166 of the Chinese version. There is a part about trials for treason or misprision of treason. We propose to remove this part in the provision. Thank you, Chairman. Mr. Holden Chow. My first question is this. On page 167 of the Chinese version concerning clause 133, this is to amend arrangements for person to be granted bail. When the NSL was promulgated, we understand that the granting of bail to the arrested person is different from that for other cases, and the threshold is different as well. I want to ask about refusal of bail. Mr. Holden Chow, we haven't got to that part yet. My apologies. Any questions concerning clause 132? If not, please walk us through clause 133. Clause 133 is an amendment to Section 9G. An accused person may be refused bail in particular circumstances. If you refer to pages 168 and 169 of the Chinese version, if an accused person is charged for the offense of treason, it is only with the permission of the judge that the accused person should be granted bail. The original provision covers murder and treason. Now we propose to remove the part about treason because we have taken into consideration Article 42 of the NSL about bail arrangement. Therefore, we propose to remove this part. Mr. Holden Chow. Thank you, Chairman. Sorry, I was way overhead just now. This is the part I would like to ask about just now. After the promulgation of the NSL, the threshold for granting bail to an accused person has changed. I see that this part of the provision is going to be amended, and it retains the original arrangement for granting bail to an accused person. I'd like the administration to clarify this. Is the amendment here reflecting the threshold adopted in the HKNSL? I see that in the provision here, there's no specific mentioning about the threshold for granting bail to an accused person in national security cases. Secretary, if you refer to clause 96 of the bill, Chapter 4 of the NSL would apply to all cases under or covered in the bill. You mentioned about Article 42 of the NSL about granting of bail. So this amendment is just to remove parts that are not applicable. Ms. Carmen Khan. Chairman, I'd like to ask about this. I'd like to go back to clause 132, subclause 3. Treason in the Chinese version is known as 叛逆, But then treason originally in the other provision means 叛國. So here you're removing the part about trials for treason or misprision of treason. That is because under this bill there will be trials for treason or misprision of treason. I want to know, you're removing this part in the provision. Is it because we're using a different wording for this? Or is it because we're not adopting the definition of treason under common law? We are codifying it. That's why you're removing this part of the provision. It says here, as nearly as possible, the same as the practice and procedure from time to time and for the time being enforced for similar cases in England. Is it because of this context that you're removing the sentence about trials for treason or misprision of treason? Mr. Leung, I thank Ms. Carmen Khan for the question. Let me explain why we are removing or repealing this part instead of adapting it. If you look at the provision, it refers to some criminal procedures without requirements under the statute law. We have to follow practices in England. There is a bracket in which treason and misprision of treason, because in England, trials for treason or misprision of treason are very different from those for other offenses. With the passage of this bill, national security cases, for trials of these cases, unless otherwise specified, the criminal procedures would be the same as those for other criminal cases. So we think that we should remove this part. You may have noticed that under subsection 3 here, there is a mention about England. We'll adapt the relevant part in other parts of the bill, but not here. It's because this bill has to do with safeguarding national security. But in subsection 3 here, it refers particularly to criminal procedures. So it's not appropriate for us to adapt the provision here. But in other parts where appropriate, we will make the adaptation. Thank you.
我呢個理解，即係話
Chairman, I would like to confirm if my understanding is correct. For treason and misprision of treason, we already have regulations and procedures for those. That is why we have to repeal this part. Thank you. Legal advisor has a similar question. Well, she's already put the question. Mr. Holden Chow. Thank you, Chairman. On subclause 3, there is a reference of the word England. Just now, the administration mentioned that they will adapt the provisions on other occasions. Earlier on, members of the AJLSP has been working on the adaptation exercise of the laws of Hong Kong. I would like to ask about the timetable for that. Now, we are working full steam ahead to enact Article 23, but as for the adaptation exercise, it may take even some more time. I'm not sure if I'm describing it in a correct way. Would something embarrassing happen because we have this reference of England in the laws of Hong Kong? If we refer to subclause 3, we're talking about procedures of criminal causes and matters, but at the same time, we provide in the clause that we should align our procedures with that of the England. I don't think that's very appropriate. Just now, the administration said that they will adapt the laws holistically later on. But before that happened, I wonder if anything embarrassing would arise. Thank you. Any response? Law Officer, Mr. Moy. Thank you. Thank you, Mr. Chow, for the suggestion and comment. We are working on it internally, and our colleagues have been looking at the operation of the provisions. When the courts are handling certain cases, they invoke such clause and provisions. But we notice that they have not cited the practice and procedures from the England rigidly. We don't have to follow the practice and procedures from England, definitely. It says here, as nearly as possible. It also says here the practice and procedure in all criminal causes and matters as nearly as possible, the same as the practice and procedures for similar cases in England. Only when we cannot find any relevant practice and procedures in Hong Kong will we have to adopt those in the England. And when the courts of Hong Kong are handling such cases, they actually tread very carefully. The judges of our court actually explained that it's not suitable for us to follow the practice and procedures of the England rigidly. That is why we are reviewing if we need to retain the provision. If we need to do that, this provision will become a fallback provision. We may try to find other ways to draft the provision so that the courts of Hong Kong can act in the interest of justice. Thank you, Mr. Chow, for the question. We are working on that, and we will propose a solution as soon as possible. Chairman, thank you, Law Draft Officer, for explaining it. I only realized just now that you are working on it. You explained that you have read the ruling of the judges, and you said that you actually do not follow the practice and procedures of the England rigidly. Just for this sentence here, which sets practice and procedures for similar cases in England, can you try to see if it's possible to delete? Can you go back and think about that? As this is an issue, and I know that you are actually looking into the matter. So why don't you just repeal the entire sentence? That's my suggestion and comment. Thank you, Chairman. Thank you, Mr. Chow, for the suggestion. We will definitely consider it, and that's one of the possibility that we're considering. Oh, that's a matter for the future. We shouldn't be adapting other ordinances while we are enacting Article 23. Any other questions? Would the administration walk us through clause 133? Thank you, Chairman. It's about amending 14A. Please refer to page 169 of the Chinese bundle. It's about what offenses can be tried in summary offenses procedure. We repeal the offense is declared to be treason, and we also amend the trials that can be handled by summary offense procedures. And it says that where any provision in any ordinance creates or results in the creation of an offense and subject to subsection 4, the words upon indictment or on indictment appear, the offense is triable only on indictment. We repeal the words treason because we are talking about offenses that can be triable summarily. If no questions, let's move on to clause 133 or 135. Clause 135 is to amend section 51. In subclause 2, it says here that if on the trial of any information, charge, or indictment for any offense other than treason, it is proved that the accused is not guilty of that offense, but the allegations in the information, charge, or indictment amount to or include, whether expressly or by implication, an allegation of another offense falling within the jurisdiction of the court of trial, he may be found guilty of that other offense or of an offense of which he could be found guilty on an information, charge, or indictment specifically charging that other offense. So here says the reference of other than treason. We propose to repeal it. Questions? If there's no questions, please proceed to clause 136. Thank you, Chairman. It's to amend section 79I. Please refer to 172 of the Chinese bundle. We propose to add subsection AB, that is, the criminal proceedings concerned are specified proceedings. We specify in subclause 3 that even if any permission has been given in specified proceedings under this section that is not yet amended, then as long as a verdict has not been delivered in the proceedings, the permission is to be regarded as never been given. And in subclause 4, we will include some interpretations, including the meaning of specified proceedings, which means proceedings of a case concerning national security, and we also provide for a definition of amended, which means amended by the Safeguarding National Security Ordinance. Mr. Holden Chow. Thank you, Chairman. I would like to know more about clause 136. So we usually allow for a live television link, but then under subclause AB, it says that for specified proceedings, live television would not be allowed. So by specified proceedings, we're talking about cases in relation to safeguarding national security. And if national security cases is involved, then we will not allow any witness to give evidence overseas via a live television link. In some cases, there could be prosecution witness who are not in Hong Kong and are willing to give evidence. How would you handle that? In criminal cases, we've discussed in the HLSP meeting about the live television link or giving of evidence via live television or live broadcast. So I would like to know more about that. Thank you. Ms. Yu. Thank you, Chairman. We agree with your comment. We need to prevent interference of evidence in cases in relation to national security. If witness is giving evidence outside of Hong Kong, we cannot make sure that the witness is giving evidence without any threats. To protect the interest of justice, we will not allow for a live television link for cases in relation to national security. I understand that because if a witness or even prosecution witness, we should not allow them to give evidence via a live television link. Correct, because they can come to Hong Kong to give evidence. Ms. Carmen Khan, can the administration explain more about Clause 3? So it says as long as the ruling has not been made, this clause would be applicable. So even before this bill is passed, live television link should not be made available. Ms. Khan's understanding is correct. This is a fundamental principle. We need to protect national security when we are handling national security cases. That is why we have such a restriction. The procedures of, say, designating judges and trying cases without jury, these are the measures to safeguard national security. That is why we provide for Clause 3, which says that any application would not be valid. Please proceed to Clause 137.
多謝主席。第100
Thank you, Chairman. Is to amend Section 91. You can refer to page 173 of the Chinese bundle. Under subsection 4 of Section 91, which says that the compounding of an offense shall not be an offense otherwise than under this section. The reference of other than treason in the original provision is proposed to be repealed. Any questions? If not, please proceed to Clause 138. Thank you, Chairman. Clause 138 is to amend Section 100, which is about abolition of presumption of coercion of married women by husband. It says here under Section 100 that any presumption of law that it's an offense committed by a wife in the presence of her husband is committed under the coercion of the husband is hereby abolished, but on a charge against a wife for any offense other than, and after that we propose to add an offense endangering national security, the maximum penalty for which is life imprisonment. Any questions? If not, please proceed. Clause 139 is to amend Section 123. Criminal proceedings may be held in camera and on disclosure of identity of witnesses in certain cases. You may refer to page 174 of the Chinese bundle. Under subsection 1, it says, notwithstanding any other law but subject to the provisions of the Hong Kong Bill of Rights Ordinance, if it appears to a court that it is necessary to do so for a purpose mentioned in subsection bracket 1AA, the court may order that the whole of the proceedings before it in respect of any offense and so on. We propose to amend in the interest of, or repeal in the interest of justice or public order or security, and add for a purpose mentioned in subsection bracket 1AA. And under subsection 1AA, we propose to add the purpose is A, safeguarding national security, B, safeguarding public order, C, safeguarding justice, and D, any other proper purpose. We will make adaptation under subsection 1B to add to be contrary to a purpose mentioned in the subsection bracket 1AA. And under subsection 1B bracket A, there was an original sentence that says, and the decision of the Court of Appeal shall be final. To be proposed to appeal it, and add subparagraphs A, B, and AC, which says also if the case is a case to which Division 4 of Part 7 of the Safeguarding National Security Ordinance applies, and so on. Part 7 means cases endangering national security. Then if the Court of Appeal grants leave, the prosecution may also appeal to the Court of Appeal against the decision of the court to refuse to make an order under subsection 1, which means that the prosecution may lodge an appeal against such cases. And under subparagraphs A, we repeal the sentence and the decision of the Court of Appeal shall be final. Under subparagraphs E, we will include such reference or decisions of a court to refuse to make orders under subsection bracket 1. Here we want to clarify that there is an appeal mechanism for refusal to make orders. Now we move on to subparagraph F. We repeal in the interest of justice or public order or security. Thank you.
委員
Reverend Peter Kuhn, Chairman. In 1AAD, any other proper purpose? My first question is what is meant by proper purpose? And second, who decides whether the purpose is proper? Who will take the question, please? Mr. Leung. Thank you, Chairman. Let me explain our line of thinking in proposing these amendments. Article 47 bracket 4 of the Hong Kong NSL, or rather Article 41, is our major consideration. The trial should be conducted in an open, fair, and impartial manner, unless in conducting an open trial, there may be a prejudice to a fair hearing. The result, however, should be made public, and this is in line with the Hong Kong NSL Article 41 principle. And it's for the court to decide what proper purpose means. The court should have regard to the Bills of Rights Ordinance and the relevant requirements to open hearing. For example, there may be personal data, privacy safeguards, and that's one of the proper purpose, but it's for the court to decide. Any other questions? No. Next, Part C, or rather, Clause 140. Clause 140, Schedule 3 amended, accepted offences. Apart from the list of offences set out in the schedule, such as manslaughter, rape, attempted rape, etc., we propose to add another offence, that is an offence endangering national security. Any questions, Ms. Kam? Chairman, can you explain the effect of the accepted offences in Schedule 3? Mr. Leung. Thank you, Chairman. For accepted offences, This relates to whether a suspended sentence can be given. That's Section 109A of the Criminal Procedure Ordinance. Basically, in a criminal case, after the judge has passed a sentence of imprisonment, a defendant may be entitled to have the sentence suspended, save and except in circumstances where this is an accepted offense. Immediate imprisonment is warranted in such a case. But it doesn't rule out other forms of sentences such as detention center, training center, etc. The court may have regard to the circumstances of the case and decide the most appropriate form of sentence. All right, Chairman, understood. I see the list of accepted offenses here. These are grave offenses such as manslaughter, rape, attempted rape, offense against certain ordinances such as possession of an offensive weapon, offense or public order offense. So I understand the rationale. The imprisonment sentence should not be suspended for these offenses. Still, the DOJ also explained that the sentence could be one of a training center. In that sense, this section is not applicable. I'm sorry, allow me to add to my previous answer. Apart from suspended sentence, Section 109A of the Criminal Procedure Ordinance also refers to juvenile defendants before they reach the age of 21. That's for those between 16 and 21. If they are convicted of an offense, the court must, first of all, consider non-custodial sentence. However, in light of the seriousness of an offense endangering national security, this should be made an exception. Of course, for a juvenile defendant, as the case authority suggests, the court should consider the rehabilitation aspect whilst metering a sentence that has a deterrent effect. And the possible sentences, therefore, are training center or detention center. Any other questions? If not, that ends part 12B. We start with part 12C, clause 141. Thank you, Chairman. Clause 141, Rule 13 amended. That's legal aid in certain cases. And that's amendments to legal aid in criminal cases rules, Cap 221D. It provides that where a person is committed for trial upon a charge of murder, treason, or piracy with violence, or B, is convicted of these offenses and proposes to appeal therefrom, or C, wishes to oppose an appeal to or apply for leave to appeal to the Court of Final Appeal in proceedings involving a specified offense, the director may, having regard to financial resources of the accused person or appellant, grant him a legal aid certificate or appeal aid certificate, and shall do so if his financial resources do not exceed the relevant amount specified in Rule 4. There is a reference to treason. Now, the original provision contains some very serious offenses. So we are replacing the original expression with this reference to a specified offense. And then in page 179 of the Chinese bundle, subsection 4, that's page 222 of the English version, we'll find what a specified offense means. That means an offense endangering national security, the maximum penalty for which is life imprisonment, murder, or an offense under section 19 of the Crimes Ordinance. Thank you. Ms. Holden Chow. Thank you, Chairman. I'm afraid we're unable to go through all the relevant ordinances. For this legal aid in criminal cases rule, the specified offense means an offense endangering national security with a maximum sentence of life imprisonment or murder, or an offense under section 19 of the Crimes Ordinance. I want to know why only 3 types of offenses are included, or rather, why do you specify an offense endangering national security with a maximum penalty for of life imprisonment? They said that for other NS cases, the defendant would still be entitled to legal aid, only that the maximum sentence is not one of life imprisonment. Can you explain to us why here it is specified that the NS case should attract a maximum penalty of life imprisonment? Thank you, Mr. Chow, for your questions. Members are, of course, well versed with the rules. When it comes to legal aid, the defendant will need to go through the means test as well as the merits test, whether there are merits of the case for legal aid to be granted. Rule 13 of the legal aid in criminal cases rules provide that if the person is committed for a trial upon a charge of murder, treason, or piracy with violence, the director may only consider the financial resources of the defendant or the appellant before granting a legal aid certificate. In other words, the director does not need to consider the merits test and the strength of the evidence. As long as the financial test is met, the director may grant the appellant legal aid. We consider whether we should just put in the offense of treason. In fact, for the most serious type of national security cases, legal aid should be given to the defendant when the means test has been passed, instead of considering the merits of the case. And that is why for the NS case attracting a maximum sentence of life imprisonment, we've put in A here. In C is actually piracy with violence, only that we've redrafted the section to mean an offense under section 19 of the Crimes Ordinance. All right, for the benefit of the public, we now understand that there is an additional safeguard for defendants. As long as this is an offense endangering national security, the maximum penalty for which is life imprisonment, then on meeting the financial resources requirements, legal aid will be provided to the appellant instead of considering the merits of the case. If there are no other questions, that's all for amendments to legal aid criminal cases rules. Division 12, amendments to the Magistrates Ordinance, Cap 227, Clause 142. Yes, this is an amendment to the Magistrates Ordinance. We propose to amend Schedule 2 so as to make it clear that these judicial officers that have the power to try national security cases. And then in the second schedule, in Clause 142, you'll find the corresponding amendments. In Part 1, there is a reference to misprision of treason and also any offense against Part 1 or 2 of the Crimes Ordinance. And also a reference to the offense of incitement or seditious, in fact, in point 7. So in point 2, we specify that it is an offense endangering national security. And then from points 4 and 5, misprision of treason and any offense against Part 1 or Part 2 of the Crimes Ordinance, etc. Again, we have deleted these provisions and replaced them with offense endangering national security. If there are no questions, then we move on to clause 106, page 122 of the Chinese version. Clause 106 provides that if a person is convicted of conspiracy to commit any offense under the HKNSL, any provision containing the penalty of the NSL offense under the HKNSL also applies to the penalty for the conspiracy, incitement, or attempt to commit this offense. There are 3 subclauses, namely the conspiracy offense, incitement offense, and also the attempt offense. A. If the person is convicted of conspiracy to commit any offense under the Hong Kong national security law, any provision concerning the penalty of the NSL offense under the HKNSL also applies to the penalty for the conspiracy. B and C respectively refer to the person being convicted of an incitement or an inchoate offense. So B, an incitement offense. It provides that the penalty for the incitement also applies unless the HKNSL itself provides for the penalty for incitement to commit the NSL offense. Because under HKNSL, apart from the proper offenses, there are also relevant penalties made out for the incitement offense. So there is an exception here. For point C, this is a similar prescription, so I will skip the explanation. Mr. Lai Kong Kwok, first round, 4 minutes. Well, I don't think many people understand what preliminary offense means, such as conspiracy, incitement, attempt, aiding and abetting. So may I ask the administration to explain what inchoate offenses entail? Thank you. Mr. Leung. Thank you, Chairman. Thank you, Mr. Lai, for your question. Now, broadly speaking, for inchoate offenses, is sometimes called preliminary offenses. So basically, the relevant acts are conspiracy, incitement, or attempt. That means that the offenses have yet to be completed. In the case of a robbery, the actus reus of robbery may not have been completed, but if there is a conspiracy to commit robbery, then at least the person is guilty of conspiracy. And then somebody might be carrying a firearm, approaching a bank, ready to rob the bank, and that this person gets caught, this person will be guilty of attempting to rob a bank. For incitement, under common law, even if this person doing the incitement has not committed the act, because of the act of incitement, this person will still be guilty of incitement. About spelling out the penalty under clause 106. This originates from legal disputes arising from the national security cases we previously dealt with, and that is why we want to make an express provision here. There are 4 types of offenses under the HKNSL with different levels of penalty. For conspiracy, incitement, and attempt to commit an offense, the issue is whether the relevant penalties should be aligned with the complete of offenses respectively or not. Now, for the conspiracy offense, according to the Crimes Ordinance, the offense itself can attract a maximum penalty applicable to the complete offense. And that seems to be inconsistent with the HKNSL. According to the prosecution in the NS case, the penalty should also be pegged to the level of severity of the offense in the HKNSL. We've yet to hear from the higher courts on this issue. But to avoid doubt, we want to make an express provision here. If a person is convicted of conspiracy, incitement, or attempt to commit any NSL offense, the penalty should be the same as the penalty for the proper NSL offense. That is, the 4 levels of penalties should apply. For secession, the maximum penalty is life imprisonment. Incitement to secession, however, the maximum penalty is just 10 years imprisonment under the HKNSL. So, of course, if this is an incitement offense relating to a national security case, then the relevant penalty under HKNSL should apply. Ms. Carmen Khan, I thank the DOJ for the very detailed explanation. Now I see how this complements the HKNSL. It dovetails with the relevant penalty levels to avoid future disputes. I think the SJ already covered that. Is this a procedural provision? Does it apply to the cases on trial at the moment? Well, this comes under the Crimes Ordinance. There is no retrospective effect. After passage of the bill, it will come into effect, and this will only apply to crimes that are committed after passage of the bill. As for cases that are being tried and the issues are being debated, it depends on the court's interpretation on the existing ordinance.
Ms. Khan, it demonstrates that as the local court hears national security cases, there are issues that the court may come across, and with this passage of the bill, I believe the issues will be sorted out in the future. Any further questions on clause 106? If not, I will wrap up item 13A. Now we come to item 14A of the reference table. That's part 8 of the bill. Administration, please. Thank you, Chairman. Clause 107 is about administrative instructions in connection with safeguarding national security. Subclause 1, the Chief Executive may issue an administrative instruction to any public servant of the government to give directions in relation to the following 4 matters. A, the implementation of any instruction given by the Central People's Government in relation to safeguarding national security. B, the work on safeguarding national security. C, the provision of rights, exemptions, facilitation, and support that are necessary for the Office for Safeguarding National Security of the Central People's Government in the SAR in performing its mandate under Chapter 5 of the National Security Law. D, any other matter that the Chief Executive considers conducive to safeguarding national security. Mrs. Regina Ip. Thank you, Deputy Chair. The Immigration Ordinance the Custom and Excise Ordinance as well as the Police Ordinance, etc., state that the public officer or the director is subject to the instruction of the chief executive. The wording used in clause 107 is a bit different, but I wonder if it has the same effect. That is, in future, public servants or public officers will be subject to the instruction given by the chief executive. The wording here used is the chief executive may issue an administrative instruction. This is my first question. Deputy Secretary, I believe what Mrs. Regina Ip was saying is that the public officers are subject to instructions given by higher ranking officers or their supervisors. However, here, we're proposing that the chief executive, as the chairman of the Committee for Safeguarding National Security, and he, as the top leader of safeguarding national security in Hong Kong, to better reflect the work or the importance of public servants in safeguarding national security, we are including this provision in the bill. We have set out the details of the work of public officers in safeguarding national security so that public servants have a better idea of what kind of work they have to do in terms of safeguarding national security. There's another part that touches on those who work for the Hong Kong Monetary Authority, Legislative Council, the Executive Council, etc. But this part only concerns civil servants, is that right? Yes, we are referring to only civil servants or public servants here. As we scrutinize this bill, a number of colleagues here mentioned about the National Security Act of the UK. That is a very detailed provision or legislation. For instance, the provision for regarding detention period is included in Schedule 6 to the Act, and it consists of dozens of pages. I remember the Deputy Secretary mentioned that it is a very detailed provision as well. So apart from the primary legislation, there is also a schedule to the Act, and there is also a code of practice. So I asked a similar question to the chief executive. I wonder if the bill is detailed enough or comprehensive enough. Will the chief executive in council spells out the rights or establishes a code of practice, for instance, for this purpose? Deputy Secretary, on the point about code of practice, it may not have any legal effect. The same purpose can be achieved by an administrative instruction. We have something known as the subsidiary legislation under the laws of Hong Kong. We will have to spell out clearly in the bill that the chief executive in council will have the right to establish subsidiary legislations. If members find this appropriate, we may consider this approach. This will ensure expedient legislation. If we take the negative vetting approach, we will be able to enact relevant legislation speedily. Mrs. Yip, there are 18 schedules to the National Security Act of the UK, and each of these schedules consists of dozens of pages. There are details set out in relation to detention procedure and so on. Yesterday, we had a discussion about ankle bracelet or electronic devices for detention. We are not as advanced as countries like the UK, we have yet to see subsidiary legislations in this regard, so I hope the administration can consider empowering the chief executive in council to establish subsidiary legislations. As for S, I hope that this bill can be forward-looking. During consultation of the bill, or during the meetings of this bill's committee, we have heard views from the general public as well as members of different sectors. Deputy Secretary mentioned about the possibility of having subsidiary legislations and schedules, as mentioned by Mrs. Regina Ip. I have also thought about whether we should have a mechanism for establishing sub-legislations to achieve the effect we want in the future. Mr. Stanley Ng. Clause 107 is about administrative instructions in connection with safeguarding national security. There are subclauses 1A to D. It encompasses a very broad scope. Can you tell us more details about this? Apart from the chief executive, should other government officials be responsible for making the instruction? I noticed that under Article 9 of the NSL, it says that the SAR government should strengthen its work on safeguarding national security and prevention of terrorist activities. The government shall take necessary measures to strengthen public communication, guidance, supervision, etc. in this regard. Article 10 of the NSL states that the SAR shall promote national security education in schools and universities and through social organizations and so on to raise the awareness of Hong Kong residents of national security and of the obligation to abide by the law. It seems like this bill has yet to respond to the requirements imposed by the NSL. So I wonder if the administration can add one more subclause to clause 107 to impose requirements on, for instance, promoting national education to show the government's determination to promote national security education. Specifically, I have the following ideas. For instance, the Chief Secretary for Administration shall promote national security education among Hong Kong residents to strengthen the government's work on safeguarding national security and prevention of terrorist activities. The Chief Secretary shall provide advice or issue directives or instructions to relevant parties. This is a very specific suggestion. Deputy Secretary. I thank Mr. Stanley Ng's suggestion. What Mr. Ng said is in line with what the Chief Secretary has been doing now, because there is a steering committee for the basic law, and the Chief Secretary is the chairperson of the steering committee, and there has been discussions about promoting national security education within the steering committee. We will look into whether it is possible to add a subclause under clause 107 to reflect Mr. Ng's suggestions. Mr. Tony Che, Deputy Chair. It says here that the chief executive may issue an administrative instruction to public servants. Compared to clause 19, which targets only public officers, this is more narrow in terms of its scope. I wonder if you should review the scope of people you cover under the clause. That's my first point. Secondly, like Mr. Stanley said, would national security education or patriotic education be included in work concerning safeguarding national security? This kind of work is also relevant to safeguarding national security, so the scope of application here is quite broad. Clause 107, subclause 2 states that any public servant of the government must comply with the administrative instruction. Some people may deliberately not comply with the instruction. How would the administration deal with such situation? Would you follow the civil service regulation? Deputy Secretary, I thank member for these views. On this area of our work, we are proposing a provision here because we think that work on safeguarding national security is important. We spell out clearly here that public servants must comply with the instruction. And if there are civil servants who do not comply with the administrative instruction, there would be penalty in accordance with the civil service regulation. On the point about the broad application scope, well, here we are only covering public servants in this provision. We will see whether we should change the wording into government departments instead, for example, to cover a wider group of people. Well, 107 concerns administrative instruction, but for clause 108, no administrative instruction is needed to order public servants to assist in work on safeguarding national security. So, how do you define work on safeguarding national security, and how do you define offering assistance in work on safeguarding national security? Is that clear to civil servants, I wonder? For instance, promoting national security education may be regarded as work on safeguarding national security. Civil servants must have a clear idea on this in order to take a proactive approach. Deputy Secretary. There are clauses that focus on people who are responsible on taking forward work on safeguarding national security, including those who work for the judiciary and for the Department of Justice, etc. There are also civil servants who handle national security cases or relevant work in their day-to-day duties. We hope that everyone within the administration would proactively take forward work on safeguarding national security. Now it's my turn. I'd like to ask about clause 107. Part 8 is about mechanisms for safeguarding national security and relevant protections. I'd like members to think about this. We've been scrutinizing the bill for a number of days now. We've been talking about the legislative intent, legal principles, and so on. I think legal principles are rather technical matters. We have to think about as well how to implement the bill and the mechanisms. As mentioned by the administration, the administrative instructions would be issued by the chief executive. The chief executive also serves as the chairperson of the Committee for Safeguarding National Security. So some of the decisions concerned would come from the Committee for Safeguarding National Security. The committee would act as the brain. And Article 12 of the NSL states that the committee has a role to play. The committee shall be responsible for affairs relating to and assume primary responsibility for safeguarding national security in the region. In the interpretation by the MPCSC of Article 42 of the NSL, the committee as well as the executive authorities of the SAR government should implement the decision made by the Committee for Safeguarding National Security. So my understanding is that the committee plays a very important role in safeguarding the mechanisms for safeguarding national security. However, as we scrutinize the bill, I have yet to see the role of Committee for Safeguarding National Security being enshrined in the bill. So I wonder if the committee or the committee's consultant as well as secretariat in terms of their duties and functions should be included in the provisions here. And as the committee makes a decision, how should the decision be implemented or taken forward? I think all these should be reflected in Part 8 of the bill. As to whether they should be included under Clause 107, I don't think it's a significant issue. However, I do think they should be included in the bill.
Deputy Secretary, let me explain the current situation. For the Committee for Safeguarding National Security and the duties and functions of the members, they have been set out in the Hong Kong NSL. As for the May 28th decision of the MPCSC, there is an interpretation of the NSL of the Hong Kong SAR. After interpretation, the part will become the laws of Hong Kong. That is why we have not provided for the interpretation of the MPCSC in the Safeguarding National Security Ordinance. If members think that by including such interpretation, it will make the bill more comprehensive, if members think that that's a better approach, we will gladly follow up on that. I hope that the Deputy Secretary and the administration will consider that, because that is a very important element. If we cannot reflect the roles of the Committee for Safeguarding National Security at Part A or in the bill, then I think that would fall short of our expectation. Mr. Tommy Chang. Thank you, Chairman. I support the establishment of subsidiary legislation under the bill. After reading Clause 107 and 108, if we not provide for the rights of the chief executive in issuance of administrative instruction, does that mean that the chief executive does not have such a power to issue the instruction? Who will take the question? Deputy Secretary. Thank you, Chairman, and thank you, Mr. Chang, for the question. Mr. Chang is correct. If we do not provide for clauses 107 and 108, there are clauses that require the executive body to carry out work on safeguarding national security and assist in such work. Under the Safeguarding National Security Bill, we want to set out the role of public servant on safeguarding national security so that civil servants know what points they have to pay attention to. And we want to provide for indicators and directions to the public servants so that they can play a better role. I understand that the Article 23 or the legislation of the Article 23 should complement with that of the May 28 decision and the interpretation. We should not repeat the things that have been stated in one another. But in clauses 107 and 108, well, the content therein has already been provided for in other documents or interpretations. So why should we repeat it? Thank you. We want to make sure that there is a convergence among different documents. We have put some important ideas of the national security law here at the Safeguarding National Security Bill, because, say, in the preamble, we mentioned that we say that we want to protect the human rights and the rule of law, as well as the arrangement for proceedings. These ideas exist in both the national security law and the Safeguarding National Security Bill. And we provide for greater details of these ideas in the bill. So that there can be a convergence effect among SNL, Safeguarding National Security Bill, and the May 28th MPC decision to better safeguard national security. If I may supplement, as mentioned in the preamble of the bill, we want to improve the law for safeguarding national security and provide for a better mechanisms for that. We've talked about the mechanisms. If you refer to Part A of the bill, we want to review the mechanisms for safeguarding national security. We have included the 28th May decision in the Safeguarding National Security Bill and the National Security Law, so that there can be a complementary and a convergence effect. Mr. Jeffrey Lam, thank you. I agree with what Mr. Tommy Chang said. But if you don't spell them out, then people would say that they don't know, especially for those who want to stir troubles. So I think that we should provide for such clauses here. In the course of the scrutiny, we discussed definition of public servant. Should we not include public servant and public officers under subclause 2 because they are people working for the Hong Kong SAR government, be they holding office with emolument or not? Deputy Secretary. Should we include both public servants and public officers here? Well, because we think that a public servant is the core part of the executive body of the government. As for other provisions, we want to include public officers. If you refer to Clause 8 of the bill, we provide for the scope in a different way. We're talking about subclause 3 of Clause A. It says that if the law of the Hong Kong SAR confers any function on a person, the function is to be read as including a duty to safeguard national security, and accordingly, any person in making any decision in the performance of the function must regard national security as the most important factor. The scope there is wider. It says if you play this function under the laws of Hong Kong, then the person should regard their duty to safeguard national security as the most important factor. Understood. We talked about public officer. But here you only include public servant. Public servants are people who are recruited or employed directly by the Hong Kong SAR. But public officer is different. Dr. Lo Wai Kwok may be engaged as an agent. He would be a public officer. That's my comment. Please consider. Thank you. Next, Mr. Chan Xiu-Hong. Thank you, Chairman. I agree with other members' comment, but may I refer members to Part A, Mechanisms for Safeguarding National Security and Relevant Protections. We've discussed if we should include public officers under Clause 107. Even if you do not include the term public officer, the chief executive may issue administrative instruction to those officers. Still, if you don't include public officer here, people may think that they are not covered or public officers are not covered. It's quite confusing because in subclause 2 it says any public servant should comply with the administrative instruction in subsection bracket 1. It seems that there is some duplication here. I think that you should state what public servants should do. And you should perhaps include public officers as well to hold them accountable. Because the title of Part A is Mechanisms for Safeguarding National Security. I read the entire Part A. Chapter 5 of the NSL of the Hong Kong SAR says that we have to comply with the work of the Committee for Safeguarding National Security and the Office for Safeguarding National Security. National security law and national security bill should complement each other. May I take a broader perspective? If we want to look at the penalty, we should go to clauses 112 and 113. Before that, the clauses are on the administrative instruction to be issued by chief executive, what should be done by the judiciary, the DOJ, and if you unlawfully disclose any personal data, then you will be subject to imprisonment of 7 years or 10 years. It seems that you want to make use of Part A to include what has not been mentioned in the previous parts. If that's the case, then we can understand this part better. I'm not sure if I should say this on the occasion when we were discussing policy matters. we mentioned that we need to provide for a mechanism to empower the chief executive and the executive council to establish a separate mechanism to safeguard national security. Should we not include it under Part A? Thank you. Deputy Secretary. Thank you, Mr. Chen, for your comment. You have given us a great idea. Mrs. Regina Ip actually proposed a similar suggestion. We will think about that to include what has not been covered in the previous part in Part A. As for the penalty included in Part A is about requirements on public servants. If we are to establish a mechanism for subsidiary legislation, then public servants and public officers may be covered. And I think that we should provide for the penalty for violation of requirements of the public servant and public officer in the subsidiary legislation. Thank you. Mr. Lo Wai Kwok. Thank you, Chairman. My comment is similar to that put by other members. On Part A, the title is Mechanisms for Safeguarding National Security. Is the administration trying to make use of this part to explain about the mechanisms for safeguarding national security? If that's the case, perhaps you should spell out the structure of the mechanism, including the role of the Committee for Safeguarding National Security or the Office for Safeguarding National Security. Or you should rename the title as Mechanisms for Safeguarding National Security and Other Matters. Because if that's the case, then I would know that you have actually provided for the structure in the preamble. Perhaps the administration should consider renaming the part here. That is Part A. Perhaps you should rename it to Mechanisms for Safeguarding National Security and Other Provisions on Protections. Relevant protections is about protections conferred to law enforcement agencies. As mentioned in the preamble, we want to provide for an enforcement mechanism to better implement the 28th May decision, the national security law, and the enactment of Article 23. After listening to the views of the members, perhaps I will give a holistic reply. Now we conclude this agenda item. Next, any other business? There be no other business. The meeting is adjourned. Please come back at 4:40 p.m.